Looking for the bar council.
Venegopal, let me say we are beginning with live streaming and you are one person who was always
But sheer coincidence, Lordship. In 2016, your Lordship had issued notice to me before I became Attorney General to assist the court as amicus. And therefore, Lordship thought about it.
Oh, thank you. I, in fact, requested Mr. Vishwanathan also to assist us because. Yes. No, after that, so that he had assisted us in another matter. We had appointed him as amicus to assist us in another matter. So I thought that matter had gone on parallelly. We thought we'll get the material of that matter also. And some directions we had issued to the Bar Council, which the Bar Council had complied with. With their consent, we had discussed how to upgrade the exam, how to improve the quality, how to improve in law colleges, how to have better verification, quality of papers. So, Nathan had given us a lot of details in terms of how in different countries, what are the concepts being done. Why should there be a negative marking in the examination of a quarter or not? So, he's given us both point of views there. We had, of course, left things to the Bar Council, but flagged all issues that you take a decision. So, in many aspects since then, in those proceedings, the Bar Council has taken upon themselves to pass various resolutions, and actually, in terms thereof, they had complied with everything in terms of examining everything and taking a call. Ultimately, power vests with them. So, I will just updating you on what has been done in the matter. And that's why we wanted some of those orders to be placed.
We have placed that in the compilation.
Yes.
My Lords, what I find, my Lords, is an investigation, and I think my friend was very enthusiastic. He has prepared Mr. Siddharth Kohli a large bunch of documentation placed before your Lordships. But from the earliest 1923,
Yes.
from the earliest year 1923, the Shamies Committee recommended that there should be an examination.
Yes.
And I find that consistently, acts after acts which have been passed, or committees which have gone into this matter, the Law Commission report, without fail, have said an examination is necessary. Additionally, training also is necessary. And that, my Lord, is contained in a list of dates which I given to your Lordships. But, 1923 was the Indian Bar Committee,
Yes.
the Shamir Committee. And in 24, my Lord, it gave its report regarding, my Lords, the grade of practitioners. In 1926, the Indian Bar Council Act 1926 was passed. That, my Lord, is item 3. And if your Lordships will be pleased to see, section 15C, the Act required the giving of facilities for legal education and training and the holding and conduct of examination by the Bar Council. Therefore, as early as 1926. In 1953, my Lords, the report of the All India Bar Committee, headed by Justice S.R. Das, Judge Supreme Court, was published, and there your Lordships will see at the last 2 lines, or the last 5 lines, the committee concludes uniform minimum qualification for admission to the role of advocates should be a law degree obtained after at least a 2-year study of law in the university after having first graduated in arts, science, and commerce, and a further apprentice course of study for 1 year in practical subjects, for example, law procedure. The state bar councils should hold an examination in these subjects. Thereafter, not only in section 28(2)(b), after such training were omitted, I'm sorry, Lords. At page 2, the committee recommended the creation of an all India Bar Council, including to prescribe qualifications for admission to advocates, to provide and make arrangements for imparting legal education, holding examinations for and training of advocates. In 1958, the 14th Law Commission report, if your Lordship should come to my Lord's, the italics portion at the bottom, pages 103 and 115. Entry into the law colleges should be restricted to a system of strict tests so that deserving candidates are admitted. A person who has only a degree of law should not be permitted to practice the profession. A person who, after obtaining his degree, wishes to enter the profession should pursue the professional course conducted by the Bar Council in procedure. Those who wish to enter the legal profession should be required to work in the chambers of an experienced lawyer and maintain diaries. Therefore, my Lord, so far should pursue a professional course conducted by the Bar Council is as necessarily to be through an examination is what I would conclude. Because the training in the chambers of an experienced lawyer is separately mentioned. 1959, the Legal Practitioners Bill, my Lords, was introduced. Clause 26, 2A. Yeah, clause 26, 2A. Course of practical training in law and the examination to be passed after such a training for admission as an advocate. Then 7. The Joint Committee of the Lok Sabha rendered its report. Committee considered that a course of practical training followed by an examination in regard to such training should be made compulsory. Therefore, there is absolute uniformity and like-mindedness in approach to this particular risk. Then, next page 3, section 24 to include practical training and examination to be conducted by the State Bar Council. As a consequence, the Advocates Act 1961, when it was enacted, if your Lordship comes down to section 24, subject to the provisions of this Act and the rules made thereunder, a person shall be qualified to be admitted as an advocate on a state road if he fulfills the following conditions, namely D, and this is the one which was later deleted and has given rise to all the problems. He has undergone a course of training in law and passed an examination after such training, both of which shall be prescribed by the State Bar Council. And then, my Lord, the Advocates Amendment Act, and if your Lordship will turn over this to my Lord's page 4.
Just 1 second, Mr. Venegopal. Where in clause D we say that he has undergone a course of training in law and passed an examination after such training.
Yes.
Because one of the issues raised is, can there be a prescription of an advocate to work with a lawyer, and that's how all these judgments arose. And second, of course, is the bar exams, though nobody is now, I think, disputing the factum that the bar exam can be held. And the issue of enrollment and vis-a-vis the bar. What would be your view on clause D? How should it be construed according to you?
Clause D.
Yes.
But D was essential.
Yes.
Your Lordship seen that uniformly from 1926 onwards, every single committee, every single bill, every single act provided for an examination and also training. Now, what had happened, and I have mentioned this in one of my Lord's articles, the students went and started it, as a result of which Parliament reacted and deleted what was an essential requirement before a lawyer could be.
That's why I'm posing the question. Is it something which the Parliament should do, or is it something which requires construction by us?
No, but this will be one of the items, entries in the list. And therefore, so far as the Parliament is concerned, it would be entitled to pass a law.
No, that's true. But the only thing I'm saying is, now having deleted it, what is the consequence? How can...
Yes.
Lord, may I submit one thing? Lord, for this, already, Lord, we have introduced the system of internship for the student right from the very beginning. they are required to be an intern under any senior, attend the court actually
That
procedure.
also called into question.
Notwithstanding the deletion.
I was actually wanting, what is the effect of the deletion,
of
whether it is
deletion, it doesn't-
capable by parliament? or it is-
No, my lord. The other provisions in the act as a whole, the scheme of the act, my lord, which I will take your lordship through in the note, permits, my lord, post-degree pre-enrollment exam, notwithstanding the deletion. The deletion would make no difference, is going to be my submission.
Okay, that's I want
And
to
there
clarify.
is, in law, my lord, provision in the Advocates Act, read in the entire scheme and my lord, the specific provision in 49, permitting my lord, the course of action of having an exam and a training. Will also construe the provisions, my lord, and the words used thereon and my lord, the case law.
Let's please see the,
And so there, my lord, is my submission, and I assume that's also the Learned Attorney General's submission is been wrongly decided. We'll be canvassing for its reconsideration.
That's what I wanted to flag. You are wanting.
Yeah.
there was a 3 judges bench judgment earlier to Sudhir, where a doctor wanted to, along with his practice, be also practice law. And there they went into the whole of it. And they said expressly that on account of the other provisions in the Act, they, so far as the fact that this has been deleted will not affect either Section 49, which is my lord, the Bar Council of India's powers,
Yes.
or the central governments. And therefore, my lord, there is a specific provision which would be attracted. And that, my lord, was ignored by, my lords, the 2 judges bench of in Sudhir, as a result of which it becomes per incuriam. And therefore, we will take your lordships. But what your lordships should notice, if your lordships will go to D again,
Yes.
he has undergone a course of training in law and passed an examination after such training, both of which shall be prescribed by the State Bar Council. Therefore, what has been deleted is, because the whole of this section 24, if your lordship will take that and see. Section 24. Subject to the provisions of this Act, subject to the provisions of this Act and the rules made thereunder, a person shall be qualified to be admitted as an advocate on a state road if he fulfills the following conditions, namely, and there you find D,
It's been
which has been deleted.
deleted
In
in,
your lordship's book, it has been deleted,
yes.
but it is only, my lord, the examination after such training, both of which shall be prescribed by the State Bar Council. This will not in any manner affect any other provision, my lord, in the Act, which gives the power to, my lord, prescribe the examination or training to, my lord, either the Bar Council of India or, my lord, the central government, which can make rules for that purpose. Then keeping this in mind, my lords, your lordships may proceed further. The Advocates Amendment Act at section 49, the following subsection at the next page were added. 8.4. The Bar Council of India may make rules for discharging the functions under this Act. In particular, such rules are prescribed. AF, category of persons, therefore not advocates, who may be exempted from undergoing a course of training and passing an examination prescribed under clause D of subsection 1 of section 24, which should be deleted. AG, the class or category of persons entitled to be enrolled as advocates. Therefore, my lord, the class or category of persons. Now, after your graduation, which is the class or category of persons who are entitled to be enrolled is a question. And there, my lord, the rulemaking power of the Bar Council of India would step in, and my lords, they would be entitled to, my lords, lay down the conditions, and this is what the 3 judges benches held. Now, thereafter, my lord, the conditions subject to which an advocate shall have the right to practice. This will be, my lord, post his enrollment and the circumstances under which a person shall be deemed to practice as an advocate in a court. Then, my lord, section 49 capital A was added, which is a power of the central government to make rules. The central government may, by notification to the official gazette, make rules for carrying out the purposes of this act, including rules with respect to any matter for which the Bar Council of India or a state bar council has power to make rules. Therefore, instead of setting out the entirety of the rulemaking power, my lord, of the Bar Council of India and repeating it, my lord, in section, my lord, 49A, and the rulemaking power, my lords, of the state bar councils, the whole of it has been brought into, my lords, or subsumed into the rulemaking power of the central government. Now, therefore, my lords, whatever is contained in section 49 regarding the class or category of persons who are be entitled to be enrolled as advocates was also a power which, under 49 capital A, the central government could exercise. And the fact that D has been omitted would not affect in any manner the powers of the central government, though, my lords, it is also the rulemaking power which the state bar council have. Then, my lord, 1973, the Advocates Amendment Act 73 was passed. Statement of objects and reasons. Pre-enrollment training. The Bar Council of India has decided that in future a degree in law can be obtained only after undergoing a 3-year course of study in law after graduation, as a result of which the age of entry into the legal profession becomes much higher than the age of entry in other professions. Therefore, felt that after a 3-year course in law, a university, it's not necessary to retain the statutory provision in the Act requiring a further examination or practical training. This, my lord, section 24(1)(d) was omitted, but that is only so far as the state bar council is concerned. It does not, my lord, affect the powers of the central government or, my lord, the powers of, my lords, the Bar Council of India. That will be the submission, and that's what is accepted by the 3 judges in their judgment. Therefore, my lord, so far as this is concerned, the submission is, this was a result, as I had stated, that of protest by the students who said we do not want an examination, we do not want a training, we have spent money in enrollment. But what has to be remembered is this: why is it that 500 colleges were all removed and, my lord, the recognition withdrawn overnight, one by one, one by one, one by one? Under it was, I believe, the Chief Justice Ahmadi who, yes, was at that time responsible for all of them being removed. Now, it is because they were substandard and they were not more in the nature of teaching shops. They were, and at the time of inspection, the Bar Council of India may tell you, just before the inspection, they get together benches, chairs, and libraries and faculty, and have them exhibited in a big building. And then thereafter, one put boards. And thereafter, my lords, they give certificates to the students. And therefore, my lord, under those circumstances, it was essential that there should be uniformity to be brought about. All these should have to be equalized to find out as to whether the minimum standards have been maintained by the law schools. There are 1,710 after removal of 500. There are 1,710 my lords, law schools today. My lords, during my time in 1952, when I went to a law college, at that time, my lords, this was a last resort because I tried to get into the engineering college. I couldn't, I failed.
That's good. That's good AD for this profession.
Oh, you first, my lord, try your chance, my lord, in the medical colleges. That was the one which was the ultimate ambition of any student who had graduated from the 12th. Thereafter, my lord, engineering. If you failed in both, the law colleges always had enough seats. You just go in and apply and take your seat. Now, secondly, my lords, after and during those years, unless you had a godfather, because there was no examination or even if there was no training, unless you had a godfather, you would start wandering around, especially in the rural areas. So far as they are concerned, for the first time graduate in law, he would not be able to find a senior before whom he could practice even in his official area or the rural areas. And therefore, it is only if you had an uncle or a father or a relative or a friend that you would be able to, my lords, even get into the profession and be able to learn what is happening in the courts. Now, of course, with the national law schools and so on, the entire scenario has changed.
Some of the best students, the National Law School has produced
Yes, yes.
the best students. So
I
it's
think
become a changeover in terms of a priority. People leave other things and join law.
Today, my lord,
The option.
today the lawyers make mostly, other than perhaps in the rural areas, they are quite well off. There was a report in 1984 by N. Madhav Menon. He had not been interested by the Bar Council of India to find out the status of the lives of lawyers in the Tamil Nadu state. And he went throughout the state and he came out with a very depressing picture. So far as 1984, so far as most of the lawyers in the official are concerned, they were carrying on agriculture or other operations because otherwise they would not be able to earn enough. And the average income was 1,000 rupees a month, which is perhaps the BPL level practically. And therefore they resorted to doubts and they resorted to illegal practices, some or other to get some amount of practice. Now all that is gone. Today, the law colleges stand on the same footing as medical colleges or in the engineering colleges.
Mr. Venugopal, one caveat. See, when we talk about the national law colleges, that is the position. You yourself said we have many colleges spread across the country. There is no consistency in the sense that, say, Tamil Nadu has one of the least number of colleges.
The Ambedkar College is very good.
But the number of colleges are still small compared to.
Yes.
You go to some adjacent states and suddenly the jump is 10. Some of them, I think UP has grown 50. The post population is there. So the issue is that possibly it's a question mark always, I must say, that where is the teaching staff coming from these? Do we have so many teachers or not? Some of the lawyers do part-time teaching. And my impression of the states I have been in the rural area still, it is a part-time profession, often. So people are practicing law and carrying on some other work also to supplement. Yes, a section of lawyers are doing undoubtedly the best, and you're getting the best of talents, and they're making the best of money more than anybody else, I think. That also is there.
Yes, some is some.
But there are sections of this country, large section, where lawyers feel it's a challenge. Those first generation lawyers have come up, there's no doubt about it. And a lot of them is spread in.
Even from the rural areas, there are brilliant lawyers.
Some of them are,
Except that their education in the lower classes are in the local languages.
that they make up.
And therefore, for them to be
We
fluent
have,
in English,
I can say, eminent judges whom I respect who came from a local language school and have done phenomenally well.
I was told that Justice Ramana came from a rural area. Many of the
Yes.
judges in the Supreme Court also perhaps started life in a rural area, but then they have shown their special talent and competence. But therefore, so far as this is concerned, there are still, other than the national law colleges, each one of them. And I believe that there will be a judge of the Supreme Court, perhaps as a visitor, in each one of those colleges, which puts them, the vice chancellor, on their toes. And there are very good colleges like Chief Justice or various colleges.
On an update, Mr. Venegopal, I had gone to Patna in the judicial exam, judicial officers which I addressed. Almost 300 plus come from a national law school in Patna, Chanakya.
Chanakya.
Lately, I would credit
I have a
him with,
doctorate, my lord, from Chanakya.
I found an interaction during a
Yes.
extremely articulate and knew what they were doing. So there is a, I think, a trend even in judicial service also of people accepting more gender friendly now. Most of the places, one third are women. Delhi, women are more than men in recruitment. So there is a changeover. It takes a little time.
But the Supreme Court of India has put in tremendous efforts to upgrade, my lord, the standards of lawyers. And your National Judicial Academy and the State Judicial Academies, which are manned by Supreme Court judges and excellent lecturers, teachers brought from all over. And therefore, my lords, we are improving. But we are a vast country. And the Bar Council of India used to say that we had over 1 million lawyers, second to the USA. But now after some voting to find out, after they eliminated a large number of bogus lawyers, I think
Verification has been of.
Weeded out.
5 lakhs have been weeded out. What is the remaining? How many are there?
7.5 lakhs.
Seven.
7.5 lakhs.
How much?
7.5 lakhs.
Are there from
Yes.
1.5 million? So
Yes.
1 million.
I remember on judicial side in Chennai, Vakran is there. We had directed an exercise to be done of verification of law. Also, sometimes you have a bar exam. The problem is there was no methodology by which if somebody doesn't clear within 2 years and he is already practicing, he would continue to practice irrespective of whether he cleared the exam. There are various nuances of it.
Therefore, my lord, today the picture has changed tremendously. So far as when I was studying in a law college, we had only the bookies to study. If we are able to master 64,
It is an esteemed book, Mr. Venegopal, which has produced many prominent lawyers of this country.
200 pages of Saman was reduced to, my lords, one daily student, was reduced to 64 pages. You studied that, question to come from the examiners would look into this also. And if you knew your whatever was there in the 64
I'm
pages,
told it was called a dukki because it used to cost originally 2 rupees. That's how it is.
therefore, now today, and there was only a one way, that is the lecturer would be a part-time lecturer. He will be a lawyer. Therefore, one day he would teach Transfer of Property Act. The next day he would teach my lords criminal law. I mean, therefore, there is no specialization. And therefore, in those circumstances, the lawyer who passed out would be of highly substantive there. There are no moot courts, there are no seminars, there was no internet down from which they could download what is the law in other countries or whatever it is. And it was something which was very basic. But today, my lords, the picture has changed there remarkably. Now, my lords, if you may continue this. Therefore, 1973, they held, and I said on account of protest by students, they say that after the last 3 lines, after 3-year course in a law university, not necessary to retain the statutory provision of the Act requiring further examination, and that is how 24(1)D met its end. And I think that is a highly retrograde step. Section 28(2)B was omitted. A committee for legal education by Justice Rancho recommended the entry to the bar to be allowed after 12 to 18 months of apprenticeship with an entry examination. The recommendations said, well, today statutorily, internship has been provided for by the Bar Council of India rules. And therefore, my lord, each one of us lawyers, we have, my lord, interns, 2, 3, 4, who every month, they'll, my lord, come, especially during the holidays, and intern. And they'll be given the briefs which we are going to argue, and they come to court, except that today, nowadays, I'm told, on account of security reasons, they're not allowed. But I think it will be a great thing for them. In all the high courts, of course, they'll be allowed. And but now, my lords, with what is it? With your No, no, with your, this, video, live streaming, your, they would be able to participate. And that's a great thing. But it is restricted, I'm told, only to the constitution benches. But
So far, it's the beginning.
it's a beginning.
Venegopal is the
And
beginning.
therefore, it should cover everything. And Gujarat High Court has been live streaming the Chief Justice's court on the for a year or 2 years. Huh? Yes, yes. I'm told that Justice Vikramanath started it.
Yes.
Gujarat. And we can just watch. I can watch the House of Lords, my lords, or even but the US Supreme Court, unfortunately, the technology is very backward because they only broadcast it so that you can listen to the arguments, but you don't see it live. Therefore,
When the Chief Justice court, many things could happen. Question was whether they should be live streamed also.
then, my lords, 1994, A.M. Ahmadi, Justice Ahmadi Committee.
Yes.
The chairman and UGC in 1926-9 wrote to the Bar Council suggesting BCI must hold an examination of the 5-year course with a minimum percentage of 50 to 60% prescribed before one could. Therefore, the UGC took it up. Then, though the State Bar Council exam had been cancelled, a plenary meeting of law ministers and law secretaries held in Hyderabad discussed reforms in legal education entry into the legal profession. Meeting recommended that admission to law college should be through a common entrance exam. It also recommended a 1-year apprentice exam should be introduced in state bar councils. Then the newly added rule. Your Lordship, come to my Lord, 1995, item 15.
Yes.
The Bar Council of India Training Rules 1995 was made. No person shall be entitled to be enrolled unless he is eligible to be enrolled, as such under Section 24 of the Advocates Act, and has undergone training as prescribed under these rules. However, while undergoing training shall be enrolled provisionally as trainee advocates. After approval of the name of the guides by the State Bar Council shall issue identity card to said provisionally enrolled trainee advocate for their identification. Then 21-10-1997, BCI wrote to the registrar of all the universities imparting legal education in India, stating that practical training was to be given to a law student prior to his getting a degree of law from the university. Then, my lord, comes today, but I have omitted, my lord, the 1996 judgment. This is 1999. Therefore, I will take your lordship with the judgment which has upheld the powers of the Bar Council of India examination.
Because of which you say this is for incurable.
So this is for
They did not consider.
Therefore, I should have put that in here. The 1995 training, it becomes at once clear that the rules are said to have been framed by the Bar Council of India in exercise of its statutory powers under Section 24(3)(d). And then, my lords, they finally hold in the last 5 lines. May therefore be held on the express language of 24 subsection 3D